one that I just completely went like right around. I didn't even consider that. And I didn't think she was, and everything she lists, she never puts down public defender.
No, she didn't put down, I don't even, all rise.
Seated. Ms. Cutts.
Thank you, Your Honor. We're here today in State of Ohio versus Crystal Face-Meer, case number 25 CR 000368. Defendant is present at open court today with her counsel, Nicholas Mitchell. Your Honor, here today on a 2-count information that was filed on April 24th of 2025. Count 1 being theft of drugs, a felony of the 3rd degree, and count 2 being theft, a felony of the 5th degree. It's the state's understanding today that the defendant will waive her right to indictment, that she will plead guilty to both counts in the information. At that time, we would ask you to defer sentencing so that defer sentencing so victim impact statements may be ordered, and any other evaluations the court is interested in. The state has indicated that we will recommend prison. There is no sentencing agreement. In addition, upon the defendant entering plea of guilty, the state would consolidate 29 CR 000370 into this case. It would be covered by the information that has been filed. And that's the state's understanding at this time. Thank you.
All right, Mr. Mitchell.
Good morning, Your Honor. Yes, we are here on the information hearing. My name is Nicholas Mitchell. I'm filling in for Attorney Eric Cherry today on behalf of Ms. Crystal Face-Meer. What Attorney Cutts has said is correct. We are here on a waiver of incident, assuming my client again understands everything I reviewed with her. That being said, prior to us beginning this morning, Your Honor, I did sit here and go through the plea with her, as well as her rights and responsibilities related to that plea, and those rights and responsibilities that she gives up as a result of that plea.
All right, thank you. All right, Ms. Face-Meer, how old are you?
31.
How far did you go through school?
I got my associates in science from the University of Akron.
Are you a U.S. citizen?
Yes, Your Honor.
Are you able to read, write, and understand the English language?
Yes, Your Honor.
All right, prior to coming to court, have you taken any drugs or alcohol or prescription medication in the last 48 hours?
No, Your Honor.
Have you been diagnosed with or treated for any mental illness?
Yes, Your Honor.
What are you diagnosed with?
Major depressive disorder and anxiety.
All right, does it affect your ability to understand these proceedings today?
No, Your Honor.
Did you get a copy of the information filed in this case?
Yes, Your Honor.
Do you have any questions about it?
No, Your Honor.
Did you review the information with your attorney?
Yes, Your Honor.
Do you understand you have a right to have your case presented to the grand jury for them to decide whether or not to indict you?
Yes, Your Honor.
Did you discuss that right with your attorney?
Yes, Your
And
Honor.
are you going to waive that right?
Yes, Your Honor.
Okay, have her sign that waiver.
Yes, Your Honor. It's easier to stand on.
Your Honor, I've received the waiver of indictment. I witnessed the defendant sign the document in open court. Her counsel signed it, and I signed it.
All right, I will accept the waiver of indictment. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand the question, or you want to talk to your attorney some more, let me know, and I'll give you more time. You understand that?
Yes, Your Honor.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand that the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, Your
Are
Honor.
you waiving that right?
Yes, Your Honor.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes, Your
Are
Honor.
you waiving that right?
Yes, Your Honor.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, Your
Are
Honor.
you waiving that right?
Yes, Your Honor.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, Your Honor.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
And if you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you could not afford to hire a lawyer, one will be provided at no cost to you. Do you understand that?
Yes, Your Honor.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, Your Honor.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, Your Honor.
Do you have any questions about any of these rights?
No, Your Honor.
Do you still want to plead guilty to these charges?
Yes, Your Honor.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes, Your Honor.
You understand by pleading guilty to these felonies that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control?
Yes, Your Honor.
All right, count one, theft of drugs is a felony of the third degree. It carries a maximum prison sentence of 36 months and a maximum fine of $10,000. Do you understand that?
Yes, Your Honor.
Count two, theft is a felony of the fifth degree with a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, Your Honor.
I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, you face a maximum prison term of 48 months and a maximum fine of $12,500. Do you understand that?
Yes, Your Honor.
Do you understand that your felony conviction will prevent you from owning or possessing a firearm?
Yes, Your Honor.
You understand that if a prison term is imposed in this case, you might have to serve a period of post-release control for up to 2 years under the parole authority.
Yes, Your Honor.
If you are placed on post-release control and violate any conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, Your Honor.
If the violation's a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes, Your Honor.
If that were to occur, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, Your Honor.
You understand that if a prison term is imposed, you are eligible for judicial release.
Yes, Your Honor.
You could be placed on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 48 months. Do you understand that?
Yes, Your Honor.
Now, has anybody promised you I would be lenient on you just because you're pleading guilty?
No, Your Honor.
Has anybody promised you what I will sentence you to in this case?
No, Your Honor.
You understand at the time of sentencing, I do not have to follow the recommendation of either the prosecutor or your lawyer.
Yes, Your Honor.
Have you had enough time to talk with your attorneys before pleading guilty today?
Yes, Your Honor.
Have they discussed everything about your case and answered all of your questions?
Yes, Your Honor.
Are you satisfied with the advice you've been given?
Yes, Your Honor.
Have you been threatened or coerced in any way to plead guilty today?
No, Your Honor.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
Ms. Cutts, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Just before running facts, just so that it is clear, I know it's not written on the form, she has other pending cases, and obviously all of those could be run consecutively as well. Just wanted that clear. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on March 17th of 2025, the Willoughby Police Department responded approximately 12:45 p.m. to Budzar Industries Incorporated on Willoughby Parkway in Willoughby, Lake County, Ohio, for a report of theft from vehicles. One of the employees, Tammy Orr, had reported her purse missing from her car. She had gone out for her morning break at 9 a.m., saw that her purse was still in the vehicle. She had multiple prescriptions in it, bank cards, driver's license, as well as some cash that she saw when she went out at 9. When she went back out around the lunchtime, she saw that her purse was missing. She went and spoke with the safety director, who was able to check the exterior cameras and saw a silver Chevrolet Colorado enter the parking lot. A white female wearing patterned leggings, black coat, and tall rain boots exited the truck and walked around the parking lot, pulling on door handles and entering vehicles that appeared to be unlocked. Other employees were notified. Nobody indicated other items missing. While officers were looking for video from other locations, another call came into the Willoughby Police Department approximately 2:20 p.m. to go to the parking lot of Knockoff's Pub, which is on Lakeshore Boulevard in Willoughby, Lake County, Ohio, for an unknown person, possibly female, going through vehicles in the parking lot. Officers responded to that location as well and learned that a Michael Butler, who works for Multi-Flow Dispensers, had been at the location servicing the bar. His work truck had been entered and several checks in a bag, as well as a metal folder containing receipts, had been stolen out of his work truck. Officers were sending out the information about the vehicle and the description of the female when another Willoughby officer saw a white female driving a silver Chevrolet Colorado eastbound on Lakeshore Boulevard. That vehicle was stopped. The driver and only occupant of the vehicle was the defendant, Crystal Face-Meer. The clothing she was wearing matched the description with the patterned leggings, the boots, and there was a coat on the passenger seat that was black. It was found in her vehicle to have the purse of Tammy Orr located. The prescription medications and bank cards and such were in there. There was no cash in that purse at that time. In addition, the bag with the checks that were valued over $1,000 were located, as well as the metal folder with receipts. The defendant indicated that she was working, but in between jobs she went into vehicles to look for cash or items to steal. Neither Ms. Orr nor Mr. Butler or any of the businesses gave permission for her to take those items. The defendant, through investigation, was found to have been convicted of a felony drug abuse offense previously, that being illegal processing of drug documents, felony 4th degree in Lake County Court of Common Pleas, case number 16 CR 000263, dated July 8th, 2016. The prescription medications that were taken from Tammy Orr that were in her purse are, by legal definition, dangerous drugs. And that's the evidence the state would have provided.
All right, Mr. Mitchell, anything to add to those facts?
Nothing in particular to add to those facts, Your Honor.
Ms. Face-Meer, did you hear what Ms. Cutts said, that the facts would show if the case went to a trial?
Yes, Your Honor.
And are those facts true?
Yes, Your Honor.
And what is your plea to count 1, theft of drugs, a felony 3?
Guilty, Your Honor.
What is your plea to count 2, theft, a felony 5?
Guilty, Your Honor.
All right, Mr. Mitchell, would you have her execute this?
Yes. Your Honor, would you like I and Attorney Cutts' signature on the
Yes,
bond as
please.
well?
Your Honor, I've received the written plea of guilty and judgment entry. I would receive that signed document of the court for counsel sign it and I'll sign it.
All right, Ms. Face-Meer, is this your signature on the written plea of guilty?
Yes, Your Honor.
And did you sign it voluntarily?
Yes, Your Honor.
Do you want me to accept your written plea of guilty?
Yes, Your Honor.
Accept the written plea of guilty. Defendant was present when Mr. Mitchell advised of all of her rights, made a knowing, intelligent, voluntary waiver. She understands the nature of the charge, the consequence of her guilty plea, and the maximum penalty. Find it to be knowing, intelligent, voluntary. I'll accept her plea of guilty. Find her guilty of count 1, theft of drugs, a felony 3, count 2, theft, a felony 5. I'm going to refer this for an updated pre-sentence report, victim impact statements. Sentencing will be May 28, 1 p.m., and the bond is revoked. Anything else, Ms. Cutts?
No, thank you, Your Honor.
Mr. Mitchell?
Not at this time, Your Honor.
All right, we're adjourned.
All right.
Maddox.
Thank you, Your Honor. We're here today in State of Ohio versus Ashley L. Rude, case number 25 CR 000-216. Defendant is present at open court today with her counsel, Jim Matthews. Your Honor, we're here today for sentencing. The defendant was last before Your Honor on March 24th of 2025, where she pled guilty by way of information to one count of domestic violence, a felony of the 4th degree. At that time, the court ordered a pre-sentence report, a psychological evaluation, and victim impact statement. The report and evaluation have been completed and provided to the court. The victim impact statement was mailed back, but was somehow not received by probation, so obviously the court has been made aware of that information. And it's the state's understanding that all parties are prepared to go to sentencing at this time. Thank you.
Mr. Matthews.
Thank you, Your Honor. Excuse me. We are asking for community control for Ms. Rude. She's been in jail for 86 days. As a result of this incident, there is now involvement with the juvenile court in relation to custody of her daughter. Her daughter is currently staying with Ms. Rude's parents. Ms. Rude is hoping to be released so that she may immediately address that issue. She does understand in speaking with her that the most pressing issue that she has, if she's going to be successful on community control, will be dealing with her mental health issues. And she has expressed that she is prepared to deal with those issues and follow what recommendations are made, Your Honor. Thank you very much.
Okay, Ms. Rude, what do you want to tell me?
I want to say I apologize for coming into your courtroom. The relationship that I was in was just a very toxic relationship and a very abusive relationship. I take full accountability for what I've done, and I've learned a very valuable lesson while within your jail. I do not plan on coming back within your jail unless it is like for me to see my probation officer. That's what's granted today. And I'm going to try to get my mental health in order.
What is the extent of your mental health issues?
I don't understand.
Well, what's your mental health diagnosis?
I have CPTSD.
You have what?
CPTSD.
What's the C stand for?
Complex.
Okay. Who diagnosed you with that?
Signature Health and Crossroads.
What is complex as opposed to regular PTSD?
It's recurrent flashbacks.
Okay. What other issues do you? What other diagnoses do you have?
I have ADHD. And
Anything else?
Yeah, intermediate explosive disorder. And I think that she said battered woman syndrome.
Okay. What treatment have you been undergoing prior to this arrest for those issues?
I go to Signature Health, and I was in EMDR therapy.
What happens at Signature Health?
I talked to my therapist. And,
Who's the therapist?
Leno Vanbrook
Which facility is that at?
in Willoughby,
How often did you see this therapist?
once a week.
Okay. And were you on medication?
I was supposed to start taking one. I'm only on ADHD medication right now.
Why not the other medication? Why not medication for other conditions?
In the past, I've had adverse reactions to meds, and I was afraid to take one. I've been medicated since I was a kid.
How long have you been going to Signature Health?
Since I was a kid. Since I think I was...
Constantly, at a regular basis?
Yes.
So, like, by regular, what do you mean? How often have you been going?
I go once a week to see my therapist.
How long have you been going once a week?
For the last 9 months.
Okay, what about before that?
A little after I had my daughter. My daughter was 3, and then stopped going when my daughter turned 4, and went again when my daughter turned 5.
Okay, you said you've been going regular since you were a kid.
Yes.
Okay, so tell me about between when your daughter was born and when you were a kid, how often were you going?
When I was a kid, I was going to Crossroads, and then they transferred me over to Signature Health. My parents would take me. My old therapist was Dr. Mickey.
How come any of this hasn't resolved your problems or helped your problems?
I'm still kind of trying to understand PTSD, so.
Well, you've indicated that you don't take the medication because you didn't like the medication because of the way it made you feel, right?
I've been cleared from having to take medication.
Cleared by who?
My psychiatrist, Jenna Crockett.
So why are you seeing a psychiatrist if you don't get prescribed medication?
I do get prescribed medication. I take Vyvanse. I haven't been prescribed medication for PTSD.
Why are you still trying to contact Joyner?
He lives at my house still. He has things at my house.
Okay, so that's why you were trying to get in touch with him or his family members as recently as Friday night?
We're here in court, so I was trying to see if he was going to be here in court. I talked to him also on the 21st in jail.
Okay.
He said that he spoke to the prosecutor, and he said he asked the prosecutor to drop all the charges. He told me to plead guilty to domestic violence, and that would be the only way that I get out of jail.
He told you that?
We were on the phone in jail on the 21st of last month. The
And he-
24th is when I had court, which was the following Monday.
So he told you to plead guilty to domestic violence, and that's why you pleaded guilty to it?
He said that the only way that everything will be resolved is if I was to plead guilty to domestic violence. He said that he wanted to press charges originally, but he told the prosecutor that he no longer wanted to press charges. He explained to me that the state picked it up and that he was sorry that I was pending all of these cases or these charges. We agreed to go our separate ways. We still have been slightly in communication, but we haven't been seeing each
I
other.
assume there's a no contact order, right?
Unfortunately, yes. I don't plan on talking to him from here on out because now there's a Child Protective Services case open, and
So what happened back in February with this incident?
I don't understand.
What happened in February, or, oh, this is December 31? December 31. What happened December 31 of last year?
We both were drinking. It was New Year's Eve, and things got really out of hand.
How?
We got into a serious argument. He was threatening to expose my medication bottles. I'm a licensed manicurist.
Expose your medication bottles, what do you mean?
I have, we both have herpes, and he thought that I was cheating,
Okay,
and he was threatening to expose my medicine bottles on Facebook.
okay.
And,
So you get in this argument, and what happens?
he said that he's been waiting to set me up for quite some time, because he was arrested for burglary.
All right, so then when the police arrived and you knew they were there, why were you blocking the door, keeping them from getting in, if he was threatening you?
I wasn't blocking the door. He had
You
me
were
back.
blocking the door. I've read that portion of the police report where you were blocking the door, they kept telling you move, you refused to move, and then when you finally moved is when they got in. So why were you blocking the door?
I couldn't move. He had me by my hair. We were in my living room.
Okay, all right. Why, then when they went in there, why were you completely out of control and they had to carry you out? They had to call two other departments to carry you out of the door to put you in the car, and you were kicking and screaming the entire way. Why were you doing that?
I have some trauma in my background from sexual assault, and
You've got a lot of problems that you haven't dealt with. Despite what you're telling me, okay, you haven't dealt with them. You may or may not go to Signature Health, okay? but whatever you're doing there, and whatever you have done there, hasn't worked one bit. Now, you were interviewed to go to NeoCap, and you were screaming at the lady that was trying to interview you such that she couldn't interview you. Why were you doing that?
Because from what I'm hearing, NeoCap has a therapy called cognitive behavioral therapy.
Uh-huh.
And I'm a victim of sexual assault. The reason why I didn't calm down when the police came, because there was
No, I'm talking about why you were screaming at this lady from NeoCap.
I don't want to go to NeoCap.
Why not?
because They have cognitive behavioral therapy.
Okay, what's that?
It's a therapy that's not good for people that have PTSD.
How do you know that?
I talked to my therapist, and here, her name's Bree from Signature Health.
Okay, so Bree from Signature Health told you to resist going to NeoCap.
No, she didn't say resist. She said she didn't think that would be good for me because,
Is Bree here somewhere that I can't see?
no.
Do you know who this Bree is, Megan? This is why I never sent people to Signature Health, okay? So did you tell this person from NeoCap that you didn't want to go there because they have cognitive behavioral therapy and Bree told you it's no good for PTSD?
No, I told her that I have a daughter, and it would create a separation, more time away from my daughter.
So which was it? If they didn't have cognitive behavioral therapy, would you have gone there?
No,
Okay, because of your daughter.
yeah,
Okay, so you didn't want to go there because of the cognitive behavioral therapy, because of your daughter, and why else?
those are the only two reasons.
Okay.
I don't think that, also, they don't have, from what I'm hearing, the other inmates were saying, they don't
Okay,
have any.
so let me stop you there, because the last thing that you should be listening to is the other inmates. Because not a one of them know what the hell they're talking about. So you'll listen to them, but you won't listen to anybody else. You won't listen to the lady from NeoCap tell you what that has to offer and why that may be good for you, because you're listening to the other inmates because they told you something about NeoCap.
The lady said that they don't have any church there either.
Okay. What lady was that?
I spoke to the NeoCap lady.
The one that you were screaming at that couldn't interview you because you were screaming at her uncontrollably, that one?
We interviewed.
You interviewed. Were you screaming at her the whole time or just
I
part of the
cried.
time?
I cried almost the whole time.
It strikes me from reading everything that you have no insight as to what your condition is. And you certainly then have no insight as to what you can do to treat your condition. That's clear to me.
I had an appointment with my psychiatrist to get on medication. I'm not medicated in jail because you guys don't even allow stimulants.
You weren't taking medication anyway because you don't want to take medication.
I was going to start taking a medication. I had an appointment set up for the 14th, but I got placed back in jail
Why did you get placed back in jail?
because there was a protection order, and I reached out to my ex-boyfriend to come pick up his things from my house.
So why didn't you listen to the protection order?
I should have called the police, and I hold myself accountable for that. I should have
Why
asked.
didn't you?
Because the police, when they kicked my door and they had the guns pointed at me, and it scared me.
Well, why did they have their guns pointed at you?
Because my ex-boyfriend lied and said that I had a knife and I was in front of the door.
Well, you were in front of the door, blocking them from getting in.
No, I was not. We were in my living room.
You were. Now, you can argue with me all day, but I'm gonna get the last word, okay? Because if I have to believe the police account of it or yours, based on their observations of you, I'm gonna believe them 100 out of 100 times. And then you're causing problems when you're in the jail. Reports of you causing problems with other inmates when you're in the jail. you were causing a problem on a certain range, and they told you to calm down, they tried to talk to you, you wouldn't listen. And then there was a lockdown. So you have no insight into your condition, the severity of your condition. You certainly don't know what to do to make it better. That's where you're at.
I had an appointment scheduled for the 14th of last month. I didn't make it to the appointment
How long you been in jail?
since the 12th of February
And you scheduled an appointment for April 14th?
when I was out on bond.
Okay.
I saw the discovery packet. I do realize that it does not look okay. I've been out of work since last October. I pulled myself out of work. I'm on a medical leave from work. I know that I have post-traumatic stress disorder. Like, I know. My condition is not always bad. It's gotten really bad. It's not always bad. That's why I haven't always been medicated. I've been cleared by my psychiatrist and I have to be medicated. Post-traumatic stress disorder with CPTSD is different than the average PTSD. It's recurrent. So it can leave, symptoms can leave.
Well,
and then they can come
PTSD
back.
by its nature is recurrent.
From what I'm hearing and from what I've been told by my psychiatrist, mine is not always a triggered severity, which I've worked 2 jobs before.
You gotta decide if you want to get help for your conditions, or you don't want to get help, and you can try to figure out how to deal with your conditions by yourself, which has been wholly unsuccessful. You can decide how you want to do it.
I have a new therapist and I like her. She's been helping me a lot. And I have tried to help myself. I pulled myself out of work and I have been consistently, when I was not in jail, I was consistently going to my therapist and I was consistently going to my psychiatrist. So it's not, I haven't been unsuccessful when it comes to that.
The same
I
people
do.
that told you not to go to NeoCap because they have cognitive behavioral therapy.
She didn't say not to go. She just said that she doesn't think that I would do well with my condition being within NeoCap.
Okay. And once again, that's why I don't have people go to Signature Health. Ms.
Do you
Cutts?
recommend usually people go to Crossroads?
No, and especially not Crossroads. Ms. Cutts?
Thank you, Your Honor. And this is a situation I know the court is aware. When the police were called, Mr. Joyner was indicating he wasn't able to leave the residence and he wanted to leave. The police came. Nobody would open the door. They specifically were asking the defendant to open the door. Her voice was closer to the door. After the officers were on the outside of the door asking, then they heard motions and it sounded like an assault was in progress. They did kick in the door. When they entered the residence, they saw the defendant striking Mr. Joyner in the living room. At that point, 2 were separated. Mr. Joyner was found to have a bump on his head. He did have some physical harm. They had been in a relationship for an extended period of time. The relationship obviously facilitated the offense, which is obviously part of what domestic violence indicates. In this case, the defendant's daughter was in the residence as well while this was occurring. At that time, I believe she was either 6 or 7 years of age. During the time that the police were trying to take the defendant into custody and remove her from the residence, she was resistant to that, sitting down, screaming and yelling, creating quite a scene in the location. As the court indicated, they did have to call other departments for assistance in removing her from the apartment. When she was in the police cruiser, she was also kicking in the cruiser. When she got to the Lake County Jail, she did cooperate to the state's understanding with the jail staff. Defendant does have a history of juvenile adjudications as well as adult convictions. Her juvenile conviction or adjudications began in 2004 with the domestic violence and misdemeanor of the 4th degree. She did have a probation violation for fighting and for cutting her ankle monitor. Her probation was continued. In 2007, she has disorderly conduct adjudication. It began as an F4 assault but was reduced to the disorderly conduct. 2008, an adjudication for disorderly conduct. 2009, she had first a single assault case and then a second case with 2 counts of assault. She had a probation violation in that case. In 2010, as a juvenile, she had adjudication for domestic violence found in the 4th degree, and then a separate case of 2 counts of assault misdemeanors. There was another case that was just dismissed as assaultive nature. As an adult, she began her criminal convictions in 2011 with a misdemeanor domestic violence. She did have a probation violation in 2012. She had 2 different cases. One was assault misdemeanor, the other was attempted aggravated assault, felony 5, assault M1, and criminal trespass M4. 2016, she has disorderly conduct taunting. 2021, possession of marijuana, and a separate disorderly conduct. There also appears to have been another disorderly conduct that she failed to appear for. It does not appear to be a conviction. I believe it was sent to collections. She has had other interactions with law enforcement that did not go through to court. There's an active protection order out of Cuyahoga County. The state's understanding is the defendant's parents, Candace and Robert Rude, received a protection order that began on June 3rd of 2024 and is in place until June 2nd of 2029. As far as indicated, there were concerns in the jail with not listening, with bullying and threatening, per the jail's information. Defendant did violate her bond. Her bond was revoked after she was in contact with Mr. Joyner. Very soon after she was released, she attempted to call him multiple times and then sent him text messages. He was not responding to those. The information that the state received yesterday is that as recently as Friday, the defendant was trying to contact Mr. Joyner, and he said he just hung up, but she's also contacting his family and trying to add them on social media. He would like that to all stop, and he just wants them to move on. Gave additional information to the court in chambers as well. Based on all of that, the state is concerned whether the defendant will follow rules of probation. She hasn't had a felony since 2012. This is her 2nd adult felony. She does have a history of assaults and domestic violence. If the court does give her an opportunity at community control, the states would request some sort of either NeoCap or residential treatment. We are concerned about her being out in the community without that additional support of an inpatient setup. She has 86 days credit. We'd also ask for a mental health evaluation, follow our recommendations, a psychiatric evaluation regarding medications, follow our recommendations. She engaged in anger management, individual trauma counseling, no use of drugs and alcohols, that all screens come back negative, that she have 1 doctor, 1 dentist, 1 pharmacy, unless specialists are needed, that she sign all releases. She's prescribed any medications, that she take them only as prescribed. That she engage in full-time work, that she have no contact with Mr. Joyner, whether it be through family, through other people, through calls, through text messages, no contact. And that she be aware if she's given this opportunity, if she violates, she would be looking at 18 months in prison. And that would be the state's recommendation at this time.
All right, I've reviewed the pre-sentence report and the psychological evaluation, listened to the defendant and counsel. I've considered all the provisions of 29, 29, 11, 12, and 13. I'm going to place you on community control for 5 years. You're going to serve 106 days in jail with credit for 86. You're to have no drugs or alcohol, and you'll be screened. You're going to enter into the Mentor Municipal Court Mental Health Treatment Program and comply with all their conditions and follow all their recommendations. You're to go to only 1 medical doctor, 1 dentist, and 1 pharmacy for prescription medication. Take your medication as is prescribed. Sign releases for probation. No contact with Willis Joyner or any member of his family, and don't have anybody else make any contact with any of them. The appropriate time obtained to maintain full employment, pay the cost and supervision fees. Ms. Wehagen, any other terms? All right. Somebody's going to come to see you in the jail by the name of Jamie Dials from the Mental Health Program. He's going to talk to you. And I suggest you don't scream and yell at him to prevent the interview from happening, that you talk to him, because they have a very specialized program working with a whole bunch of people that are in this business that can help you, but only if you want to be helped by them. Do you understand that?
Yes.
If you don't want to be helped by them, scream at them, don't do the interview, and I'll find you violated and send you to prison if that's what you want. Okay? You can either try to help yourself, because this has been going on for more than 20 years with you. And nothing you have done has worked. Nothing you have done has helped you. It's only gotten worse. So figure out if you want something or somebody or some program to help you. Or spend the next 20 years kicking around in and out of prison. That's up to you. Anything else, Ms. Cutts?
No, thank you, Your Honor.
Mr. Matthews?
No, Your Honor. Thank you.
That's it.
All rise.
warrants out there. I don't know exactly where, but the bigger issue is there's an APA hold.
Okay, so what do they have to come see me?
Well, it depends, because I can ask the judge to terminate your.
All right.
Seated, Ms. Gold.
Thank you, Your Honor. We're here in the state of Ohio versus Melissa Hotchkiss, case number 25CR261. The defendant is present with counsel Bill Watson. We were last here on March 24th, 2025, where the defendant pled guilty by way of information to count 1, aggravated possession of drugs, a felony of the 5th degree, and count 2, possession of heroin, a felony of the 5th degree, both in violation of revised code 292511, and count 1 had a forfeiture specification. We are here today for purposes of sentencing.
Mr. Watson.
Thank you, Your Honor. May it please the court. I know we had some discussions back in chambers off the record. I know Ms. Hotchkiss is a repeat defendant in front of this court, and mainly due to drugs. She has a serious drug problem. She uses drugs, gets caught, ultimately ends up going to prison. I know she's had opportunities for treatment in the past, which she has not successfully completed or even attempted to do in some instances. She goes to prison, she comes out, and she gets caught with drugs again. It's been a revolving door in her life. Now, I've met with Ms. Hotchkiss several times throughout, and she has told me, Your Honor, that in the past, she simply didn't care. But now, she does. And I know I'm going to look at her past and her track record as to help determine what to do on this case. So, based on that, that would indicate that she's probably not a very good candidate for anything other than prison. But, and you'll hear from her in just a second, Your Honor, you know, sometimes it takes people different routes to hit rock bottom. And I think in Ms. Hotchkiss's case, she has hit her personal rock bottom. She's told me that she's tired of drugs, she's tired of going to jail, she's tired of going to prison, but ultimately she's tired of being high all the time. She wants to be sober. I know I mentioned in chambers, my office, the social worker who works for my office, Erin Mayer, M-A-Y-E-R, she has secured a bed at the Hitchcock Center for Women that would be available as early as this Friday. I know there were some recommendations for prison if the court would consider anything other than prison, a community control sanction, even if it doesn't include Hitchcock Center. I believe the defendant would be receptive to it because I believe she's sincere in her desire to change and to sober up. Your Honor, again, I know her record does not reflect a very positive outlook, but I'm asking the court to give her an opportunity on community control. Thank you, Your Honor.
What do you want to tell me?
Oh, excuse me. Yeah. Like Mr. Watson said, like I've been to prison several times. You know, prison's never really helped me.
Well, it doesn't help anybody.
And I just need to change. Like prison is I go to prison, and I just haven't. I'm not getting anything. I'm ready for something new.
Didn't we try to change that in the past several times? Haven't we tried to change that?
Yes, with NeoCap. Yes.
Well, how many times you been on probation here?
None, or just the once, but I was in NeoCap. I was sentenced to NeoCap, and I left NeoCap, and then I never did the probation because I just got.
Why did you leave NeoCap?
I just wasn't ready. I wasn't ready to get clean and sober. The drugs had a hold of my mind at that point still.
Okay. Why did you tell Miss Randallson that you weren't going to go back to NeoCap for this case?
Because NeoCap, I almost completed NeoCap, and again, my mind wasn't right, but it wasn't helping me. I've never done.
Well, why would it help you if you had no interest in it?
Because I did try it first.
I know. Okay.
I tried for 3 months.
So you want me to send you to Hitchcock, which you can get up and walk out anytime you want, right, without any consequence?
Well, there'd be consequences because I'd violate probation and go back to prison, and I'm ready this time. Like, something changed in me. Like, I don't know if it's an epiphany or what, but like, I'm just done. I'm done, and I'm ready for a change. I've never been in a residential treatment facility, like Oak House or Nevaeh or Hitchcock or any of those places, and
Why not?
Well, when I was on the streets, I wasn't ready, and it was just getting.
Why would I believe you're ready, if that's the term you want to use?
I don't know what I can say to persuade you into that, but
Probably nothing.
yeah,
but-
exactly. I mean, I guess I need a chance so I can show you. Jail just hasn't sit with me this time. Like, something's different in me. I can't explain it. Like, there's just something different. Like, I'm losing everything. Like, and I know it's not materialistic things, but I'm losing. Like, I don't have a chance. I'm gonna die. And I know that. I know if I go back out, I'm gonna die.
What is it you're losing?
My self-will, my family. My dad's sick with cancer. My fiance is done with me. If I go back out again, like, I've lost my children. I need to be in my children's life. I want to be in my children's life.
How old are they?
They're older. They're 17 and 14.
So why weren't you ready a few years ago, if
I don't
that's the
know.
case?
I can't. I don't know. This time just is different. It's just different for me. Like, I don't want to dig my hole deeper right now by saying things, but like, before in jail, like, I was like just there, like, having fun, playing cards, like, cutting up, you know, having a good time. And like, this time it's just not. It's just I can't do it. I'm done. I've hit my bottom. Like, there's nowhere deeper to go.
Well, there
besides
is.
death.
Right.
And I can't do that. Like, I'm scared to death to die.
When did this happen?
In August.
You hadn't been out of prison that long, right?
I got out in March.
So you're on post-release control right now, right?
Yes.
What contact have you had with them?
None.
None?
No, I didn't know how to get a hold of them while I was in here.
I assume they came to see you.
No, they haven't.
What contact did you have with them when you got out of prison?
Up until I caught my case in August, they were coming to my house, I believe it was monthly. And then I was calling if I needed to speak to her about something, but it was regular up until I caught the case. Miss Roxanne Stram, I believe her name was.
What did they do when they came to your house?
They just questioned me, asked me if I had police contact, if I was still sober, just the normal questions. They've came in the house a couple of times, just check it out. But my fiance would be at work, so it was harder for me to get up to the office, so they would just do like a home visit.
So when you got out of prison, what were you doing?
Well, I started going to meetings and I was trying to focus on my mental health, and then I slipped, and then it was the drugs. I got back into the drugs, I'd say 3 months out.
Who were you going to for your mental health?
Stride Mental Health, Dr. Terrell in Shaker Heights. He's a psychiatrist and a psychologist.
And what were you doing there?
Counseling and medication.
What kind of medication?
Suboxone, gabapentin, anxiety medication, depression. You want specific names of medication?
Yeah.
Abilify, Lexapro, Vyvanse, Suboxone, and gabapentin.
Okay. How often were you taking the Suboxone?
Up until I relapsed, it was daily. Or how many times? Like, I took a 3-day.
What do you mean a 3-day? 3-day
I
dose?
I took 3 doses a day.
Did you,
and I was
when you
taking,
took a heroin on this occasion, did you get sick? Because you were on the Suboxone?
Well, that's what I took it for like the first 2.5 months, and then I stopped taking it when I relapsed.
Did you tell the psychiatrist you stopped taking it?
No, I stopped going
Why?
because I was scared to tell people I relapsed. I was scared for people to find out.
Why don't you just go to prison for 6 months, you'll be out in a few months, and you can do anything you want.
Because I want to get better. I don't want to, prison, like I said, prison doesn't,
What makes you think that me sending you to Hitchcock or anywhere else is gonna make you better?
I just hear that it's helped a lot of people. I've seen a lot of people go into a program and come out and stay clean for like 10 years. Like when I'm in and out, when I go to meetings, I see people with 20 years that, you know, got out of Hitchcock, like, and Hitchcock helped them.
Why did it help them?
Because they listened to suggestions and stayed clean, just didn't pick up. But other than that, like I want to find out myself. Like I said, I've never been able to do the residential treatment.
Well, you have, you just haven't wanted to.
Yeah,
You could have done it on your own, right?
yeah, absolutely.
Ms. Gold?
Thank you, Your Honor. The state does not believe that the defendant is amenable to community control sanctions. In her last case in 2022, the defendant was given community control sanctions as her sentence and escaped from NeoCap and was subsequently sent to prison. In this case, based on the defendant's lengthy criminal history and based on her prior conduct while on community control sanctions, the state is asking for a prison sentence.
How did you escape from NeoCap?
I went to the hospital. I had a seizure. Should I stand up? I had a seizure, and I went to the hospital, and they left me there, and I left.
They left you there?
Yeah.
Where was that?
Tri-Point.
Okay. And they left you there?
Yeah.
How'd you get caught?
I don't know. Somebody must have called and told me because I was only on like the run, I guess, for 9 days. Well, 9 days. I made it 9 days.
Where were you?
Cleveland.
Where do you live now before this?
908 Hardy Road, Painesville.
With who?
My fiance.
All right. I reviewed the pre-sentence report and the updated pre-sentence report and the old drug and alcohol evaluation. Listen to Ms. Hotchkiss and listen to both counsel, considered all the provisions in 29, 29, 11, 12, and 13. So by the time you had gotten here for the first time in 17, you had already been to prison and had several convictions, so I sent you to prison. October 17 through September of 20. And you get one in F5 drug case in Medina. I don't know if that's ever been concluded. Right, Kim, there's a warrant out on that still from 24/9/18 to 24. You got a warrant, Medina?
Yes, sir.
And And a few months later, you get a felony in Middleburg Heights. It's reduced in common police court in Cuyahoga to a misdemeanor. 6 months later, you get a drug possession in Garfield. And a couple months after that, F3 possession here. I put you on probation. Sent you to NeoCap. Disappeared. Somehow you managed to get a misdemeanor out of that. Not sure what happened there, why that was. So you go to prison as a result of that. Get out in January of 24. And then 7 months later you get this. So you got the warrant out from Medina from the 21 case, Garfield for the 22 case. Did you have a little run-in with Ashley Root over there at the jail?
Yes, she's in my pod.
What was that all about?
Do I have a run-in? What do you mean? Oh, sorry.
Well, did you have some dispute with her?
No, I haven't had any problems with anybody in the jail at all. She was in the holding cell with me just a minute ago.
I know that, because she was just here.
Yeah, no, we're in the same pod, and if you have an issue with somebody, they separate you guys and keep separates.
You put in a request form about Root in March saying that she was threatening people.
Okay, so the girl that she was threatening didn't want to write it out, so it was put in my name, but it wasn't my issue. She was like scared and intimidated by her, and I just put the kite in my name, and it was like the whole pod that signed it.
Okay, so I've considered all the statutes. I'm going to place you on community control for 5 years. You're going to serve, when's that spot ready over there at the Hitchcock house?
Your Honor, I was told either this Friday or this coming Monday, if the court wants to give her an additional 10 or 15 days, I'm sure the bed will be available within that time period, Your Honor.
All right, I'm going to give you 70 days in jail with credit for 54. When the spot's ready at Hitchcock, you'll be taken there by a representative of the PD's office. The rest of the days will be suspended. Complete that program and follow their recommendations. Re-engage in mental health treatment and follow those recommendations. 4 AA or NA meetings a week, and obtain a sponsor. Only 1 doctor, 1 dentist, and 1 pharmacy for meds. Meds is prescribed, sign releases, get full employment at the appropriate time, get a valid driver's license. Resolve the warrants. Pay the costs and supervision fees. Kim, anything else?
No, Your Honor.
Okay, I'm not a big believer in this working because you've demonstrated that it doesn't work, but it doesn't matter what I believe or disbelieve. Now, I don't know what the adult parole authority is going to do with you. That's up to them. Probably nothing, because that's kind of what they do best, is nothing. But if you violate here, I'll send you to prison for 24 months. Then you might be on post-release control again for 2 years with conditions. You violate, you go back to prison. It's a new felony, you could get an additional consecutive prison sentence. You've heard all this before, so you know exactly what I'm talking about, so. One of two things is gonna happen. I'm either gonna see you back here again, or I'm not gonna see you back here again. You decide which it's gonna be. Anything else?
Forfeiture of items, Your Honor.
Forfeited. Mr. Watson, anything else?
Nothing further, Your Honor.
Here, try to make a believer out of the people at the probation department,
Okay,
okay?
yes, thank you, sir.
All right, so Aaron's gonna be taking you today.
And then which lady?
No, either this Friday or this coming Monday.
Okay, he's suspended then.
Yeah.
Okay.
All right, Mr. Mulkey, anything to add?
No, Your Honor.
Mr. Palmer, did you hear what Ms. Contour said? The facts would show if the case went to trial.
Yes,
And are those facts true?
yes, they are.
What's your plea to count 1, aggravated possession of drugs of felony 5?
Guilty,
And what is your plea to the forfeiture specification?
guilty.
Mr. Mulkey?
Thank you, Your Honor.
That's all right. Here, you can take this back. Thanks.
Date of 5/7/25. Then I'll sign the prosecutor's signature to the judge.
Mr. Palmer, is this your signature on the written plea of guilty?
Yes, it is.
Did you sign it voluntarily?
Yes, I did.
Do you want me to accept your written plea of guilty?
Yes, please.
I'll accept the written plea of guilty. Defendant was present when Mr. Mulkey advised of all of his rights, been a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, voluntary. Will accept his plea of guilty and find him guilty of count 1, aggravated possession of drugs, a felony 5, and the forfeiture specification. I'm going to refer this for a pre-sentence report. Sentencing will be on June 5th at 3:45. Anything further, Ms. Contour?
Nothing further, Your Honor.
Mr. Mulkey?
Nothing further, Your Honor.
All right, we're adjourned.
I'll be out to see you.
Lila. Believe me, I've dealt with it. No. Thursday?
All right, love you.
Love you. Thank you.
I really have a cold and hot. Been trouble last.
seated. Ms. Gold?
Thank you, Your Honor. We're here on the state of Ohio versus Trayvon Hopkins, case number 24CR1155. The defendant is present with counsel Carly Snavely. A 3-count indictment was filed in this case on January 31st, 2025. This indictment was subsequently joined with the indictment in case 24CR1156. So counts 1 through 3 are the originally indicted counts in case 24CR1155, and counts 4 through 6 are the counts from case 24CR1156 that are now joined and renumbered. Counts 1 and 4 are receiving stolen property felonies of the 5th degree in violation of revised code 2913.51A, and counts 2, 3, 5, and 6 are identity fraud felonies of the 5th degree in violation of revised code 2913.49B2. The state has offered for the defendant, should intervention not be granted, to plead guilty to counts 2 and 5. Upon a plea of guilty to both of those counts, the state would agree to recommend community control. Should intervention be denied, the state is asking that the defendant plead guilty to the entirety of the indictment.
All right, Ms. Snavely, do you want to address the intervention motion first?
Thank you, Your Honor. I have had the opportunity to review the intervention report and the pre-sentence report that was, I guess not really a pre-sentence report, but the full report prepared by the probation department, as well as Lake Geauga Recovery Centers. It does appear that Mr. Hopkins is eligible pursuant to the report prepared by Lake Geauga Recovery Centers. We would certainly support the recommendations and findings set forth in the intervention report, as well as any other sanctions or any other conditions that this court deems appropriate. I've conferred with my client about it at length. You know, he does seem genuinely remorseful and is very motivated to avoid any felony convictions. I've explained to him that I don't request intervention on every client that is eligible for intervention if I feel that I'm setting them up for failure. As was indicated by the assistant prosecutor, he would only be required to plead guilty to 2 felonies, 2 5th-degree felonies versus 6 if the court is willing to grant him the opportunity to participate in intervention. And should he fail to successfully complete intervention, he would subsequently be convicted of all 6 felonies. And I think that incentive, together with the opportunity just to avoid it, would be, I think he's a good candidate. I wouldn't have filed if I did not think he was capable of doing so. And I would ask this court to give him that opportunity. Thank you.
All right, Ms. Gold, as to the motion.
Thank you, Your Honor. The state is asking that the defendant's motion for intervention be denied. The defendant does have a lengthy misdemeanor criminal history. As written in the report, committed this offense and has been charged, not convicted, but charged with another misdemeanor after the indictment. And this case was filed, and it is the state's position that in addition to that intervention would demean the seriousness of the offenses. In this case, the defendant did commit crimes where there are 2 victims, and he made the conscious choice multiple times to use these victims' credit cards. The state does not believe that intervention is appropriate in this case.
All right, I've reviewed the pre-sentence report and the Lake Geauga report, and Mr. Hopkins, by statute, is eligible, although kind of right on the periphery of what's intended for the statute, but I'll grant the motion. Mr. Hopkins, how old are you?
How you doing, sir? Nice to meet you.
You
I'm
can stay
25 years
seated.
old. Sorry.
How old are you?
25 years old.
How far did you go through school?
High school and then 1 year of college, Lakeland Community College. For
Are
business.
you a U.S. citizen?
Yes, sir.
Are you able to read, write, and understand the English language?
Yes, sir.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No, sir.
Have you ever been diagnosed with or treated for any mental illness?
Yes. I have major depression, MMD, bipolar depression.
Now, you gotta speak up a little bit for me.
Bipolar depression, and depression, major depression disorder, med management, post-traumatic distress.
Are you being treated for any of those conditions?
Yes, sir.
Where at?
At Action Recovery in university hospitals.
All right, are you currently taking medication for that, any of
Yes.
those?
Yes, sir. I also have seizures. I'm taking quepapine, Keppra, Lexapro, Seroquel, gabapentin, Lexapro, and more on this file.
When is the last time you took any of those medications?
I take them mainly like probably 2 days before.
2 days ago?
Yes.
All right, does the condition or the medication affect your ability to understand what's going on here today?
No, sir.
Okay, with this intervention, you're gonna be pleading guilty to all 6 charges in the indictment.
Yes, sir.
And then if you plead guilty to those charges, the criminal case will be stayed and you'll be placed on a plan. If you complete the plan, then the charges will be dismissed. If you don't complete the plan and I find you violated the conditions, okay?
Yes, sir.
Then I'll terminate the plan and you'll stand convicted of those 6 charges. Do you understand that?
Yes, sir. I understand.
All right, now, so I'm gonna ask you a bunch of questions leading toward, if you acknowledge the rights and waive the rights, then you'll enter the guilty plea. So we're gonna go through the rights one by one. I'm gonna ask you if you understand them and if you're gonna waive them, okay?
Yes, sir.
Now, if during the course of this discussion, you don't understand a question, stop me and ask me, or if you wanna talk to your attorney, stop me and I'll let you talk to her, okay?
Yes, sir.
Now, you have on all these charges, you have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
After the witnesses are done testifying for the prosecutor, then you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the right to testify at a trial if you want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, then you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you filed an appeal, you'd have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you couldn't afford a lawyer, one will be provided at no cost. Do you understand that?
Yes, sir.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you couldn't afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, sir.
If you would plead guilty, then you would not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any questions about any of these rights?
No, sir.
Do you still want to plead guilty to each of these charges?
Yes, sir.
You understand by pleading guilty, you're fully admitting your guilt to the charges.
Yes, sir.
You understand by pleading guilty to these felonies that if you get convicted, then I sentence you, you're voluntarily giving up your freedom for whatever period of time that I could sentence you to prison, to jail, or to community control.
Yes, sir, I understand.
Now, counts 1 and 4 are both receiving stolen property. They're both felonies of the 5th degree. Each of them separately carry a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
I understand, sir.
Counts 2, 3, 5, and 6 are all identity fraud. Each of them are separately are felonies of the 5th degree, and each separately carry a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, sir, I understand.
You know, if you get sentenced, I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I gave you a consecutive sentence on each of the counts, then you face a maximum prison sentence of 72 months and a maximum fine of $15,000. Do you understand that?
Yes, sir, I understand that.
Any question about that?
No, sir.
All right, do you understand that if you're sentenced and you are sentenced to prison, that upon your release, you might be placed on post-release control under the direction of the parole authority for up to 2 years?
Yes, sir, I understand.
If you are placed on post-release control and you violate any conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, sir, I understand.
If the violation were a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes, sir.
And if that were the case, the maximum prison sentence would be either 12 months or the time left under post-release control, whichever is more. Do you understand that?
Yes, sir, I understand.
You understand that if you were sentenced to prison, that you would be eligible for judicial release?
Yes, sir, I understand.
Now, if you were sentenced in this case, I could put you on community control for up to 5 years, but if you violated any conditions, then I could send you to prison for 72 months. Do you understand that?
Yes, sir, I understand.
Now, has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No, sir.
Has anybody promised you, if you get convicted in this case, of what I would sentence you to?
No, sir.
Do you understand that if I sentence you, I don't have to follow the recommendation of either the prosecutor or your lawyer?
Yes, sir, I understand.
Have you had enough time to talk with Ms. Snavely before pleading guilty today?
Yes, sir.
Has she discussed everything about your case and answered all of your questions?
Yes, sir.
Are you satisfied with the advice she has given you?
Yes, sir, I'm very satisfied.
Have you been threatened or coerced in any way to plead guilty today?
No, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, sir.
Do you have any questions at this point?
No, sir. I just want to say that I'm very much apologize and sorry. Just thankful for you to just hear out my testimony and
All
everything.
right, well, I'll hear a little bit more from you in a little bit. Ms. Gold, if the case went to trial, what would the evidence show?
Thank you, Your Honor. The facts would show that between June 20th, 2024 and July 2nd, 2024, as part of a course of criminal conduct in Lake and Cuyahoga County, the defendant received and retained Mary Bell's firefighter's credit union card with reasonable cause to believe that it had been obtained through the commission of a theft. On June 20th, 2024 and on July 2nd, 2024, the defendant did use that credit card with the intent to represent Mary Bell's personal identifying information as his own without the consent of Mary Bell. And the facts would continue to show that on August 8th, 2024, between that date and August 18th, 2024, as part of a course of continuing criminal conduct, the defendant received and retained a firefighter's credit union card belonging to Latrice Whitlow, having reasonable cause to believe it had been obtained through the commission of a theft offense, and that on August 7th, 2024, and on August 18th, 2024, in Willoughby Hills, Lake County, Ohio, the defendant used Ms. Whitlow's personal identifying information as his own without her consent.
All right. Ms. Snavely, anything to add to those facts?
No, Your Honor, thank you.
Mr. Hopkins, did you hear what Ms. Gold said, that the facts would show if this case went to a trial?
Yes, sir.
And are those facts true?
Yes. Yes, sir.
All right, what is your plea then to count 1, receiving stolen property, a felony 5?
Guilty.
What is your plea to count 2, identity fraud, a felony 5?
Guilty.
What is your plea to count 3, identity fraud, a felony 5?
Guilty.
What is your plea to count 4, receiving stolen property, a felony 5?
Guilty.
What is your plea to count 5, identity fraud, a felony 5?
Guilty.
And what is your plea to count 6, identity fraud, a felony 5?
Guilty.
All right, Ms. Snavely, if you could present this copy to Mr. Hopkins, please.
This is, I'm just acknowledging everything we just went over on the record.
Your Honor, I've witnessed Ms. Snavely and Mr. Hopkins sign the written plea of guilty, and I have signed it myself in open court.
All right, Mr. Hopkins, is this your signature on the written plea of guilty?
Yes, sir.
Did you sign that voluntarily?
Yes, sir.
Do you want me to accept your written plea of guilty?
Yes, sir.
Accept the written plea of guilty. The defendant was present. Ms. Snavely advised of all of his rights and a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, voluntary. I will accept his plea of guilty to each of these 6 charges, all felonies of the 5th degree. I'll stay the criminal proceedings, and I'll place him on a 5-year intervention program. Ms. Snavely, anything you want to say with regard to the program or anything else?
I don't believe so, Your Honor. I would ask the court to follow the recommendations set forth in the assessment or the intervention report prepared by Lake Geauga, with the exception that I would ask that he be permitted to continue in the treatment program at Action Recovery. It's my understanding he is engaged there, although I don't have any sort of written confirmation of that. It's my understanding that is through University Hospital and is a dual diagnosis program. I believe that he's attending both in person and virtually.
Okay, Mr. Hopkins, what do you want to say to me?
Sir, I just wanted to say I'm truly, truly sorry. I've just been in a real dark place after I got shot in my head back in November 2022. I just been scared for my life. I ended up been on leave from my work because I've been scared for my life. The guys haven't been caught yet, so the case still has been going on. And I've just been trying to find ways to get back in society by peers and everything, because I've been scared for my life. Just been in my home, just having like real bad nightmares, and just like I can't go around the block without like fearing for my life and everything. So truly sorry about this. All this just has happened. Just want to be forgiven.
What treatment do you have from that wound? Do you still have treatment going on?
Yes, sir. I have nerve damage that I just have been diagnosed with Kevin Doce at University Hospitals. So nerve damage to my eye from the gunshot wound, and I still have seizures come on, so I have to get like radiation scans and stuff like that. Still going through healing process, getting my skin to be like back to normal and everything. So I am going through a lot, still going through a lot of treatment with this, still on medication for this, and it's just been bringing me down a lot, you know. Just feel like I just want this to get back to my normal life.
Are you able to work?
Right now, no, I'm on Social Security, so I was just wondering if I could be granted the individual program, because it would affect my Social Security if I get felony, sir. So I just wanted to be an honest opinion.
And Your Honor, I will actually state for the record that he has since been granted Social Security disability since this incident. So hopefully that will prevent any future reoccurrences of any type of behaviors, now that he does have an income.
Okay. All right. So I'm gonna give you terms of the plan. If you follow the terms, then eventually these charges will be dismissed. If you don't follow the terms, then the state will file a motion to terminate your plan. If it finds you violated, I'll terminate it, and then I'll sentence you. Do you understand that?
Yes, sir, I understand.
So you're gonna serve the terms of the plan are as follows. You're going to serve 4 days in jail with credit for 4. You're gonna complete the dual diagnosis program and action recovery. And you're gonna follow all the recommendations that they make. You're to have no illicit drugs and no alcohol, and you'll be screened. So you gave me a list of drugs that you're prescribed, right?
Yes, sir.
So it's, I'm going to assume that any other drugs that are not prescribed to you would have a negative effect on the drugs you're taking. And if you're drinking, like you have in the past, it's going to have a bad effect on you. You understand that? So you can't do that.
Yes, sir, I understand.
And you're going to be tested periodically for those things.
Yes, sir.
You're to have no contact with either Whitlow or Bell.
Yes, sir.
Have you ever had a driver's license?
Yes, sir.
All right. When did you lose it?
I just gained them. The suspension just came up in January, so I'm going to get them back before June 9th. I have one on the 28th.
So one of the provisions or one of the conditions, you get a valid driver's license.
Yes, I'm getting those right before June 9th, sir.
All right, and you pay the cost and supervision fees. Anything else, Ms. Wehagen?
Your Honor, I would just, I guess for clarification on the record, it's my understanding that Mr. Hopkins does have a medical marijuana card, and I would ask the court that he be permitted to continue using that. It's my understanding it has helped him considerably with the post-traumatic stress, and though it is not a prescription, but a recommendation, I would ask the court to accept that.
What do these other doctors that are prescribing all this other stuff say about that?
Saying that I very much need them. I have everything, all my paperwork right here, if you wanted to look over it for me.
I mean, do they know that you have that card?
Yes, sir. Yes, sir. They granted it for me. Yes, sir.
Well, they didn't, but where did you get it from? Who did you talk to get that?
The Ohio medical marijuana.
Okay, some doctor somewhere.
Yes, a doctor. Yes, sir.
From where? Which doctor?
It's on the card. It's in the card.
Is that a phone? You made a phone call to a doctor? Or is that how?
No, I got it on. It's from University Hospitals. I got it from over there from them, from Dr. Sherry Epen, my doctor, and she got me a hold of them. And it's
your doctor at UH gave you the doctor's name
the
that made the recommendation?
Yes, sir. And the office is in Beechwood, so.
Was it a phone call to somebody in Nebraska?
No, sir.
Okay.
This is all in Ohio, in Beechwood, Ohio. I have proof of everything too. So
all right. Well, then you can do that. You can use that. Ms. Wehagen, were there any other terms you thought applicable? All right. Do you understand all the terms, Mr. Hopkins?
Yes, sir. I understand.
Okay, like I told you, if you violate, the state will file a motion. If I find you violated, then I'll sentence you and you face a potential of 72 months in prison. You understand that?
Yes, sir. I understand.
All right. Anything else, Ms. Gold?
Your Honor, I apologize. Where is the dual diagnosis treatment to be completed?
It is called action recovery.
Thank you.
Anything else, Ms. Snavely?
Nothing further for me, Your Honor. Thank you so much.
All right. We're adjourned.
Thank you, Your Honor.
Honor. We are present in the state of Ohio versus Alicia Austin, case number 24 CR 1020. We are here today for purposes of sentencing. The defendant is in court represented by counsel. When we were last here on March 21st, the defendant pled guilty to an amended count 1, possession of cocaine, a felony of the 3rd degree with the attached forfeiture specification, and the court referred the defendant for a pre-sentence report and scheduled sentencing for today. That report has been completed, and I believe the parties are prepared to proceed with sentencing.
Ms. Tomaszek?
Yes, thank you, Your Honor. We would like to ask the court today to place Ms. Austin on community control sanctions and allow her to do drug and alcohol and mental health treatment and speak with Ms. Austin. She indicated to me that she is interested in a very long-term treatment plan. She is interested in doing inpatient for as long as possible and then residential to sober living environment. She knows it'd be very beneficial to her. At one point back in 2017, she did have a period of sobriety. She indicated to me she was sober for 18 months. I don't have any documentation of that, Your Honor. It's just that what Ms. Austin has told me. And speaking with Ms. Austin, she indicated to me that you revoking her bond and her sitting in the Lake County Jail has been a blessing in disguise for her. She's been able to get a clear mind, be away from drugs, and she's able to focus on herself and know what she needs to do. While in the jail, she has been attending the NA and AA meetings that they do hold in there. So that's been really helpful for her. She does have a small support system. She has some members of her family who are a great support system for her. She also does have an old peer support group out of Cleveland, I believe dating back to when she was sober. She indicates she still speaks to some of them, so she can also rely on them. I do think with the help with the Lake County Probation Department, though, it will help set her up for success and help her take those steps to remain sober and get sober. She does also have 3 young kids. I know she wants to be there for her kids, but she does know that she needs to focus on herself first, maintain sobriety, then she could be there for her children. Thank you.
All right, Ms. Austin, what do you want to tell me?
Can I read it? I just want to say, I learned from my mistakes. Being away from my family has been very detrimental to my life. I realize that the severity of my actions and regret being in bad situations. I've learned and I want to do better. I can do better and I will. I have had over 18 months clean. I was the secretary of my home group and everything, you know, and everything. I'm very adamant about getting back, you know, getting those that clean time back, and then, you know, in so many more years. I've reached out. I've been so adamant about it that I'm so serious about it that I have reached out to a few places myself. I'm just tired of using. I'm tired. And I know being here, you know, in the Lake County Jail, it has been, you know, it's really like showed me that that's God. That was God doing for me, and I wasn't doing for myself. And that was saving my life.
All right, Ms. Aleshi?
Thank you, Your Honor. The state is recommending community control sanctions to include drug and alcohol treatment. Given the defendant's criminal history, the prior convictions for drug-related offenses, as well as the offense here, I think that a long-term treatment option would be appropriate. She has attempted or even successfully completed drug and alcohol treatment in the past, yet unfortunately did not apply those treatment tools, and yet here we are again today. So the state is recommending a drug and alcohol treatment and the forfeiture of the property. Thank you.
All right, have you been diagnosed with any mental illness?
Yes.
What?
PTSD, bipolar, insomnia.
Were you ever treated for any of that?
Yeah, I was with Signature Health, but they haven't been giving me my meds in there.
Okay. All right, I've considered a pre-sentence report. In the previous forensic examination that considered all the provisions in 29, 29, 11, 12, and 13. I'm going to place you on community control for 4 years. You're going to serve 109 days in the jail with credit for 69. The last 30 days you're going to be in the jail treatment program. You're going to complete that and follow all recommendations. After you finish a jail treatment program, you're going to go to NeoCap. You're going to complete that program and follow all those recommendations. When you get out of there, you are going to enter and complete a sober living facility, stay there for a minimum of 6 months. You're to have no drugs or alcohol, and you'll be screened. At least three AA meetings a week, and obtain a sponsor, get a mental health evaluation and follow all the recommendations. Obtain your GED, get a valid driver's license, obtain full employment, and pay the cost and supervision fees. Any other terms, Ms. Crook?
No, Your Honor.
You understand the terms, Ms. Austin?
Yeah.
You have any questions about any of them?
No, I don't think so.
Any questions at all?
No.
All right. If you fail to comply with the terms, then the state will file a motion to terminate your community control. And if I find you violated, then you face potentially 36 months in prison. You understand that?
Yes.
All right, the item subject to forfeiture are forfeited. Anything further, Ms. Alicia?
No, Your Honor, thank you.
Ms. Tomaszek?
No, Your Honor, thank you.
All right, we're adjourned.
All right.
ready, then give me a call. I'll explain everything to you.
She scared the shit out of me sitting in jail for almost 2 months. I'm cool. Scared the shit out of me. I don't want to do no more time.
Seated. All right, this is 23-1071, Dominique Maddox, violation of the intervention plan. First violation, test positive for marijuana December 4. You understand that charge?
Yes.
Second, self-reported use of marijuana February 26. You understand that charge?
Yes.
Cited for no operator license, driving under suspension, and some other things on February 25th in Mentor. You understand that charge?
Yes.
And failed to report December 19th. You understand that charge?
Yes.
All right, Ms. Tomaszek, final hearing. What do you want to do?
Yes, thank you, Your Honor. I've had a chance to speak with Mr. Maddox regarding the violations, and he wants to admit and plead guilty to the charges today. With regarding Rule 1, though, cited for no operator's license, Mr. Maddox did go to Mentor Municipal Court, and those cases have been dismissed. He just has some fines to pay by mid-July, Your Honor, and he does have documentation if you would like to see it.
All right. All right, so Mr. Maddox, what's your plea to those violations?
I plead guilty, but I tried to make sure I got everything else taken care of, so that I didn't have to say that I was doing anything else wrong. I do understand what I did, and the time you made me sit down really put a shock on me and a big eye opener to just having freedom and being out here. That it got me pretty squared away, honestly, that,
Goddamn, I hope so. 'Cause
Yeah,
you've been
no,
a chronic pain in the ass since July.
yeah, no, and I don't want to be no more of a pain to you because that time you really made me sit down. Like, it was a big eye opener for me, and as shown, I've got everything required done, and actually, hopefully on Friday I can go take my actual driver's test, and I'll actually be like legally driving again. So past that, I just want to say I do admit to that wrong, and I think I understand now that you're not playing around with me, and I don't want to play around with anybody else. I enjoy freedom.
All right, because remember, you're on this intervention plan, right?
Correct.
So you're not convicted of anything as long as you complete the plan.
Correct.
Okay? And you've been trying to not complete the plan because you've been here like 4 times since then.
Yeah, and I understand that. So, which I would like to, if so, complete it and actually get this not on my record, but from here on, I think I'm pretty square on.
All right. I'm going to continue the plan so you're still on it and get that license, and then all the other terms that I gave you remain in effect for those that have not yet been completed. All right?
Understand.
Anything else from the bleachers over there? All right, anything else, Ms. Tomzik?
No, Your Honor, thank you.
Okay, Mr. Maddox, don't come back no more.
I will not.
All right.
so they're both here. Both residential. You're gonna read it. Let's see what it does. Get a sponsor that you worked with previous. Pardon? Okay. That's what, make sure you spell it out. No, make sure you tell the sponsor.
All rise.
Seated. Bonche.
Yes, Your Honor. We're here today for sentencing in two cases, each involving the same defendant, each case being styled State of Ohio versus Briana M. Arnold. Ms. Arnold is present today in open court with her attorney, Mr. Ken Nelson. The first case, that would be 23 CR 1194. Defendant on March 24th of this year pled guilty to 4 counts of the indictment, all violations of 2925.11a. Count 1 being possession of cocaine, a felony 5 with a forfeiture. Count 2, possession of fentanyl, a felony 4. Count 3, aggravated possession of drugs, a felony 5. And count 4, possession of heroin, a felony 4. On the other case, 24 CR 896, defendant also pled on March 24th to 3 counts on a separate indictment. Again, all violations of 2925.11a, all F5s. Count 1 being possession of fentanyl with a forfeiture specification, count 2 possession of cocaine, and count 3 possession of dangerous drugs. On both of these, Your Honor accepted the plea and ordered a PSR and a drug and alcohol evaluation. We are ready for sentencing. There is no agreement as to sentencing in either case. On the case ending 1194, we understand that the defendant has served 74 days jail on that one. And the case ending 896, we understand that it is 71 days that this defendant has served, Your Honor. Thank you.
Mr. Nelson.
Your Honor, that is accurate. I just wanted to say for the record, I have had a chance to review the Lake Geauga recovery report dated April the 23rd of 2025, as well as the pre-sentence report. I didn't know if the court wanted to hear from my client first, if that'd be permissible, or if you want to hear from me first.
Either, whatever you want to do.
Your Honor, if you could hear from my client, is it okay if she remains seated?
Yeah.
Okay. Dear Judge O'Donnell, while being in jail, I have learned to be humble. I have prepared myself to live a new, sober life and to accept my old life as a lesson plan. I have accepted my consequences due to my actions. I understand that I had to have tough love and discipline to change my way of thinking. Attached to this, I have prepared a relapse prevention plan with 3 different scenarios that have previously triggered me to use, and what I would do different if these situations were to happen again to maintain sobriety. I accept the court's decision on my behalf. I trust the courts have my best interest at heart and truly want what's best for me and will guide me in the best direction to live a sober life in society. Thank you for giving me another chance and opportunity to change. I want nothing but the best for myself and child. I know he needs a sober mommy so I can fight out there and not from in here for him. I will not let the courts, myself, and family down with the help of my sponsor, Becky Casper, and support group. I will complete treatment, IOP, attend meetings, and to stay sober. I will work an honest program. Thank you.
Nelson.
Thank you, Your Honor. The reason I wanted you to hear from my client, I think, as you can tell, she has the skill. She's been in treatment. She has the skill. She knows what to do. It's just a matter of giving her the chance to actually do these things to succeed. She has a sponsor. The sponsor is active in her life. She has a relapse prevention plan to prevent these things from happening again. She's had some time to get sober while she's been in the jail. She's had a chance to think through these things and think of plans of attack going forward. And why that is so important is she has a 10-year-old son. She has a 10-year-old son that has a pending custody visitation case across the street over at the Lake County Juvenile Court. She accepted responsibility for both these cases, the 23 case as well as the 24 case. 4s and 5s drug offenses, Judge. She admits that she has a drug problem. She knows it's a battle, and she's looking to get treatment. She has a bed available at New Beginnings in Ashtabula as well as in Square One. I personally think Square One is a little bit better because it can treat the dual diagnosis that I think was the recommendation from the probation department as well as the late Geauga recovery report, Judge. But either one I think is suitable. Either one I think would help her to address her issues. And more importantly, from my perspective as well, both of them would provide transportation to and from court so that she can continue to participate in the Lake County juvenile case with her son. So my hope and recommendation is that the court does give her the opportunity to go to inpatient treatment at either New Beginnings or at Square One, where she could continue to work towards sobriety, and she would be able to address the custody and the visitation matter that's pending across the street, Judge. She is a high school graduate. You've heard her speak. She's well-spoken. Her mother's a litigation specialist at a law firm. She has had a chance to go to some paralegal schools. She's certainly bright. She just needs to stay sober. She's learning through some of the treatment. She has a plan. I think she deserves a chance to execute on that plan, Judge.
You were in Cuyahoga Drug Court back in 2018. Where did you complete an inpatient treatment program?
CATS, 90-day program. I've completed CATS.
That was inpatient?
Actually, it was inpatient. It was 90 days plus another 30 days I completed, and then I went to Whitehaven and completed that. And
Okay, so why did you get back to the drugs again?
I stopped working the program. It was actually that was in Cleveland, and I live in Lake County. So it was kind of, once I got done with all that, it was kind of hard to work out there, and then with the sponsor and home group from out there. I got a new home group, the Night and Day Club, which is right next to my house now. But it did work for me. I was sober for 2.5 years after I completed the inpatient treatment.
So why did you go back to using then after you were sober for 2.5 years?
Different triggers. Like I said in my relapse prevention plan, I had a car accident in 2023, lost my job as a manager at Denny's for 5 years due to the car accident with no transportation, and
Well, you had an attempted drug trafficking in Mentor Municipal Court in early 21.
Yes. That I never went back to. That was a lesson learned.
Huh?
That I never went back to. That was a lesson learned for me, for sure.
What do you mean?
I learned my lesson from that. I never trafficked again after that.
Okay, you just used though. You were using
Yeah.
all over the place.
I did.
Why?
I don't think I knew how to stay sober then until I worked a program. I didn't know what it was to have a home group and a sponsor and a support system and support for my family. I didn't know
Well, when
how.
did you get a sponsor and a
Back
home
in
group?
2021.
Okay. So why were you using again during the course of this case? When this case happened and then throughout until I locked you up again?
Because for some reason I thought I could fight for my son alone and not reach out to my family and realize how much support that I actually had to fight for him. So to cope with it, I decided to use. And once I decided to use, it was too hard for me to go back.
How long have you been in this battle for your son's custody?
It actually just started, kind of.
It's my understanding, Judge, and correct me if I'm wrong, please, the child a little over a year ago was sent to live with her father in Virginia.
Yeah.
With his father in Virginia, but the case has just been recently filed over in Cuyahoga.
Well, I temporarily signed custody over so that I could complete this program and get this, in a plan going so that his father doesn't fight custody like he's trying to do. So. And his father's in the Army. It's just not the best thing.
You disappeared for a while,
I did. The plan was to go to court for Braylon over a Zoom appearance on Friday, and I got arrested on a Thursday. I was gonna go to court
I know,
for
but
him
why did you disappear?
because I didn't wanna go to jail before I showed up for that Zoom custody court
Well,
case.
you weren't, you had a pretrial on October 2nd.
Okay, first I got,
And you were here, then
Yes.
you were supposed to appear at probation on November 20th, you didn't appear. You got arrested 5 months later, and you came here, pled guilty. I let you out on an OR bond, the next day you're positive for fentanyl and cocaine.
yeah.
Why?
Which part are you asking?
All of it.
Okay, I left treatment, successfully completed treatment, and then got COVID, which was, the papers were sent over to Jennifer. And then after COVID, she rescheduled it on a day of a blizzard that I couldn't appear for. Called the office at probation, didn't get a response from her. So I do admit I failed at that part. And then, yeah, I decided to use, and my way of thinking then was much different than it is now. You know, now
That's only like 6 weeks ago.
I didn't have this time to be sober to sit and think, you know what I mean? I've sat and thought about a lot. I
Yeah, but
realized the
didn't you
support that
tell
I
me you were
had.
sober for about 2.5 years in the past?
And, yeah, but that was in 2021.
Right.
From 2018 to 2021.
Okay. So that was a long time to be sober
Yeah.
after the way you were before that, yet you went back to it.
Yeah, it's hard. Getting sober is the hardest thing that I've ever done in my life, but I know I can do it. I know what to do and how to do it.
Then why don't you do it?
I think before, I didn't really think that I had anything to lose, and now I realize that I have my son to lose now.
Well, he's 10 years old, right?
He's 10, and I've had him all 10 years until now.
Right.
So now I realize that, you know, I think before, and then leaving court, like you said, when I was the next day, subconsciously, I just wasn't thinking until I had to sit in jail for over 30 days, you know, and I'm like, wow, I'm actually at peace, you know. I don't think I really thought about it. And now I've had the chance to sit and think and really do some soul searching.
Now, this square one stuff, you were in Youngstown,
Yes,
and according, you indicated to Ms. Knaus that you successfully completed it in October of '24.
yes.
Successfully completed what?
I successfully completed the Square One treatment program.
Which was what?
It was a mental diagnosis, so like they worked with my mental health and they worked with, you know, sobriety.
Judge, if I could speak to that a little further. Square One also has, when you complete the program she completed, they also have like a 3/4 house step down following that, as well as like another sober living facility after that. I don't believe she pursued both of those avenues. I think that those would greatly help her, just being in more of a.
Well, I guess I'm trying to figure out what successfully complete means.
She completed the inpatient portion of it.
Which was what?
How long was the inpatient portion?
It's 30 to 60 days, but they recommended Signature Health after. That's what I didn't complete, was outpatient.
So if you just completed it, why would I send you back to the same thing? Because it didn't work, right?
Well, the treatment place was great. It's the IOP after that I didn't complete. I didn't have a chance to do that. That's why also.
Well, you had a chance to do it, you just didn't want to do it, right?
Yeah,
I mean, nobody's taking a chance away from you.
right.
They do have the more structured, as opposed to the straight ILP, they do have a more structured three-quarter house program as well, Judge. Didn't know what it would be like.
Because I have experience with nannies.
Mr. Tavanchi?
Yes, thank you, Your Honor. State doesn't object to probation, but we would like to emphasize several matters. Some of them already mentioned by the court. Just to emphasize, the defendant does have a history of felony convictions related to drugs. Your Honor mentioned 2 attempted trafficking convictions. Those were in fact reduced from actual trafficking. So I would surmise that in fact her actions are not just affecting herself, but directed outward toward others. She has, as Your Honor knows, a history of failing to appear on these matters. Your Honor, she was arraigned in July of 2024 on the 1194 case, and here we are almost a year later. Bond was revoked 3 times in that one. She was in and out of jail several times on that case. On the 896 case, where she committed that one while she was on bond for the first one, and these were about 7 months apart. She had bond revoked twice on that one. She mentioned at one point that the reason she wasn't able to appear for those required hearings was that she was in treatment but had not told her attorney. Of course, being in constant or regular contact with her attorney is a condition of bond. I especially think that she would do that if she were doing something to get herself right. I'd also say that she doesn't take responsibility. In her PSR, on one case, she says that someone else put drugs in the console of the vehicle that she was driving. Never mind that in the same instance, she had drugs found on her person at the time. If we're to believe her self-reported treatment, then she's had quite a bit of it. As Your Honor mentioned, that stuff has not worked. It has not been enough. So it is the state's position she does need a heavy hand. If she's not amenable to NeoCap, then we would suggest prison. NeoCap would be the preferable route so that she may be able to get ready to receive and raise her son. Thank you, Your Honor.
When did you first start using drugs?
2017.
Why?
I was in an abusive relationship and then he later passed.
From what?
Xanax and alcohol, which either of those was not my drug of choice.
What was?
At the time it was Percocet, and that progressed to heroin or fentanyl.
Okay, so why did you start taking this stuff?
Domestic violence.
But I don't get the correlation. Domestic violence and you start
From him.
taking...
You know what I mean? And then he passed and I just didn't know how to deal with it, or...
Well, well, quite frankly, why would you give a shit if he passed if he was beating on you? I don't understand that. Tell me that.
I was using before that, when he was being abusive, you know what I mean? I didn't stop. I didn't even know how to get clean back then until I went to CATS, and then I realized how to get clean.
Why didn't you rely on your parents at that point? You seem to get along well with both of them.
I do, but neither one of them have a drug problem, so neither one of them knew how to deal with sobriety or how to get clean or what to do. But they were both very supportive. And we all had a great relationship with my probation officer and my counselor at the time.
many different judges have you been in front of since all this nonsense started?
Judge Mattia, which is through Cuyahoga Courts, and then in front of you.
Well, weren't you in Menor too?
The trafficking case,
Okay, then yeah, Menor.
Judge Trevitz.
Oh, was it Trevitz? Okay, Judge Trevitz.
And then Willoughby.
Before that went to the
Yeah.
Okay.
All right, I've reviewed the pre-sentence report and the Lake Geauga report. Listened to Ms. Arnold and counsel, considered all the factors in 29, 29, 11, 12, and 13. And I'm going to place you on community control for 5 years on each case. On 1194, 90 days in jail in the Lake County Jail with credit for 74. On 896, 71 or 86 days in jail. 87 days in jail with credit for 71. You're going to go to square one and complete the dual diagnosis inpatient program and follow all the recommendations. And if those recommendations are you to go to the 3/4 or halfway, you go there. After you complete your square one obligations, you're going to go to a sober living facility for a minimum of 6 months and follow all those recommendations. You'd have no drugs or alcohol, and you'll be screened. You're to attend at least 5 AA meetings a week and obtain a sponsor. You're to go to only one doctor and one dentist and one pharmacy for any prescription medication. Take your medication as prescribed. You're going to sign releases for probation, obtain and maintain full employment at the appropriate time. Get a valid driver's license and pay the cost and supervision fees. Any other terms, Ms. Knaus?
I don't believe so, Your Honor, thank you.
All right, so all those other terms are concurrent in the 896 case. Do you understand the terms?
Yes.
Any question about the terms?
No.
Judge, just to be clear,
Yep.
she has about 16 days to serve then,
Yeah.
and then she's ordered to go to square one after 16 days.
Yep.
Okay.
You understand that?
I do. Thank you.
Thank you, Judge.
All right, if you don't comply, the state will file a motion to terminate your community control, and if I find you violated on the 1196 case, you face potentially 60 months in prison. You understand that?
Yes.
And on the 896 case, there's a potential of 36 months in prison. You understand that?
Yes.
And then if you go to prison on those cases, if I find you violated and I sentence you to prison, then you may be on post-release control for up to 2 years. And then you'll have to listen to them for all that time.
Okay.
So I don't know whether I don't know whether it's going to work or not. I don't know whether what you're telling me is real or bullshit. I don't know. Okay, but it doesn't really matter because you're either going to do what you have to do or you're not going to do what you have to do. Okay? If you come back, then I'll know what to do.
Okay.
Anything else, Mr. Demonte?
Your Honor, did you mention forfeiture?
For everything subject to forfeiture is forfeited.
No objection, Judge.
Well, I was going to overrule it if you did. Anything else from you, Mr. Nelson?
Judge, I just want to thank you for the consideration. Thank you for giving her the chance, and I